Your Honor, number 4 on the list is Commonwealth versus Karen Reed, indictment 22-CR117. Can the attorneys please state their appearances?
Adam Lally for the Commonwealth. Good afternoon again, Your Honor.
Hey, Mr. Lally.
Good morning, or good afternoon, Your Honor. Attorney David Yannetti on behalf of Karen Reed. Behind me is Attorney Ian Henchy, who has filed an appearance. He's my associate. Also at counsel table are Attorney Alan Jackson and Attorney Elizabeth Little, regarding whom there is a motion to have them admitted pro hoc vice, which I'm hopeful that the court would allow.
I saw that. Any objection to the motion for pro hoc vice?
To whatever extent I have standing on it, Your Honor, no.
I don't think you necessarily do. Okay. That will be allowed. All right. A raft of motions were filed in the last couple days. Are the parties prepared to address any of them?
So, Your Honor, as a preliminary matter, these were filed by the September 15th deadline that the court had set. However, they are admittedly lengthy, with a lot of meat to them. I did confer with ADA Lally. He's asked for more time to respond to some of the motions. So we have agreed, subject to the court's approval, that we are strictly dealing with motions of preservation today. So if I could address, and my co-counsel could address those specific motions.
All right. So I have a motion to compel discovery. That we're not dealing with, right?
That would be on the next court date.
Motion for discovery regarding circumstances of a Mass State Trooper's assignment.
For the next date.
All right. Motion for preservation of samples for independent forensic testing.
I would like to be heard on that
Is
motion.
there any opposition?
No, Your Honor.
Okay. I don't think you need to be heard.
Great.
Allowed without opposition. Motions to renew motions previously filed in the Stoughton District Court prior to indictment. Were those motions acted on in the Stoughton District Court?
They were, and allowed by Judge O'Malley.
All right.
In Stoughton.
Any reason that those shouldn't be adopted here?
Your Honor, some were not. If we could reserve those for the next date, I really am only in a position to address the preservation today.
Okay. Motion for an order under Rule 17, that would be in the next date?
Actually, with regard to that motion, Your Honor, we're asking for preservation of those cell phones. And Attorney Little is prepared to address the court on that issue to the extent that there's an objection today. We expect that we would ask for production of the data on the next date.
I'm just looking at the motion. Is there something in the motion that asks for them to be preserved?
There, Your Honor, with permission, Alan Jackson on behalf of Ms. Reed.
Yes.
And by the way, thank you for granting us pro hoc vice status. It's a pleasure to be before the court. With regard to that motion specifically, there was not a preservation request. We didn't know what the time frame was going to be for the hearing, nor the actual presentation, if there is going to be presentation of the actual evidence, the phones and the data concomitant to the phones. All we're asking for right now is an oral order by the court to preserve the data until the next, at least until the next court hearing, which we hope will be October 4th.
Where are the phones?
We believe they're in the possession of the individuals that are named in the motion, and Ms. Little can name those for the record. We're not asking for any affirmative action on behalf of or on the part of any of the individuals, simply that they do not destroy, delete, alter, or in any way manipulate the data on those phones until the court has an opportunity to hear the motion.
Mr. Lally?
Your Honor, I'm not really sure what authority the court has to do that, specifically without a preservation request being part of the motion. These are physical objects that are in the possession of third parties. So I question whether or not the court has really the authority to do that. But I certainly can reach out to each of the individual witnesses and advise them of the presence of the order. The question I have as well in regard to that is following along with the process pursuant to Rule 17. First, there's no Rule 17A2, so I'm not really sure what posture we're in as far as my requirements to provide notice to the third party record or object holders. So that was my initial sort of assessment is dealing with the next state as a 17A2 hearing and then scheduling a Rule 17 further beyond that after providing notice to the parties, the third party holders of the particular objects. But I'm not sure really what counsel is asking the court to do in reference to physical objects that aren't in possession or custody and control of the Commonwealth and our personal cell phones that may or may not even exist at this point. I can't speak to it either way.
What do you say the authority is that I have under Rule 17A2 or any other authority to compel a third party who has not yet been ordered to produce any documents, and the court's made no finding of relevance, to order them to preserve information on in their database, if you will, the phone's brain?
I believe it's the court's inherent authority to order the prosecution to at least notify the third party individuals that the prosecution, the Commonwealth, is now on notice of, that it's at least the court's intent that data not be destroyed. It goes to the inherent fairness of the process. They know that we want data from the phones. They now are on notice that we want data from the phones. If that data is thereafter deleted, destroyed, altered, manipulated, or in any other way sort of gone from our grasp, if you will, I think that's at their peril. That's at the Commonwealth's peril. They're now on notice that we are seeking this data. We have no control to go get it other than to ask the court to provide it to us via Rule 17. We've made that motion. We've done our due diligence. Between now and then, all of the individuals that we're in a public filing that we're seeking the data from are now on notice that we're seeking that data. I think if the court were to order the Commonwealth to simply notify the individuals, that's the intent of the court, that none of this data be altered or manipulated or deleted, that would satisfy us as long as there's a compliance component with that and the Commonwealth is deemed to have provided us and the court some level of satisfaction that he's at least attempted to reach out to these third parties to say, don't delete, don't destroy, don't get rid of this evidence.
Have you given those witnesses notice?
Have we?
Yes.
We have not, of course.
Why not?
Well, because we just filed the motion. And there's no way for us to give them notice unless and until the court, I believe, under Rule 17.
They're third parties, right? You could send them a letter saying, we're filing a motion with the court to get this information. Please don't destroy it.
We could. Or in alternative to that, I think it would have more power and certainly more punch if the court were to order the Commonwealth to do that exact thing and it comes on the Commonwealth's letterhead. I can certainly send a letter. I don't know that they wouldn't take that letter and round file the letter. I think it would have a different impact.
Do you have a proposed form of order you want the court to consider?
I would ask the court to simply make an oral order to Mr. Lally that he is to notify each of the witnesses named in the Rule 17 to the best of his ability, that nothing is to be deleted, altered, destroyed, or in any way manipulated.
I don't like oral orders because they can be misconstrued and can't be enforced very easily. Mr. Lally, what is your view about notifying these folks? I think you just volunteered to do it a minute ago.
I certainly, again, so what my interpretation on this would be is, as far as where we are in the process, is I can certainly treat today as a 17A2, but again, I'm not prepared to address relevancy at this point, but sort of skipping ahead to a certain extent, I'd have no issue as far as forwarding a typical Rule 17 notification along with a copy of counsel's motion to each of the respective parties. But I do not feel comfortable ordering them to do or not do whatever with items that are in their personal possession, at least at this juncture.
All right, Mr. Jackson, if you want a preservation order, it's going to have to be in writing from me, okay? And you can draft it and send it into Mr. Roach by email. I'll consider it. I'll circulate it to Mr. Lally before you send it in to Mr. Roach. And you can do that, this afternoon or first thing in the morning. Understand. And I'll take a look at it and understand that this is simply putting these folks on notice. This would be a letter from the Commonwealth, essentially attaching an order from the court, putting these folks on notice that this motion is pending and that there's going to be a hearing on it on a certain date. And that the court has, and that the cell phones and the data on it should be preserved until the court can act.
Happy to do that, Your Honor. Thank you.
All right. So that one I'll hold on to until I see this proposed form of order. If you send that order in Word form, it would be easiest for the court because then I can play with it if I feel like it's necessary.
Absolutely.
There's an amended motion to compel modification of a preservation requests.
Yes. Your Honor, if I can address that motion, it actually ties into our motion to renew motions previously filed and allowed in the Stoughton District Court, because we did get an order or the Commonwealth, I should say, was ordered to notify Google to preserve geofence data, and there were specifics regarding that order. The most important part were the location and the dates.
Okay, and does that expire?
It doesn't, but it hasn't been complied with, and that's part of. And not only that, the
How do you know it hasn't been complied with?
because the preservation requests that have been sent to me from the Commonwealth do not comply with the court's orders. So if I can just be heard briefly, Judge, the Stoughton.
Before you go,
Yes.
is this a motion you're prepared to address today, Mr. Lally?
In the respect of the request, and I'm not sure there interplay between some of the motions that I saw, but as far as a motion to preserve any and all information received, I have no issue with that. But as far as the rest of it or the substantive portion of the motion, I'm not addressing that today.
That was my understanding, Judge. The preservation aspect of this is all we are seeking to accomplish today. These were allowed back in May by the Stoughton District Court judge. We still do not have evidence that Google has been ordered to preserve what Judge O'Malley ordered the Commonwealth to request them to preserve. In the motion itself, there's a couple of paragraphs about the sort of the procedural history.
What I don't see attached to the motion is what you say the district court ordered.
That is actually attached to my motion to renew motions previously filed in Stoughton District Court. It's
So that's
other.
attached to another motion.
Correct.
So where is that?
The court had previously,
Yep, I've got that, but
as you can see, there are several motions, Judge.
this is the motion to renew motions previously filed in the Stoughton District Court, but I'm trying to find the right attachment.
Right.
Nothing is tabbed here, so I just have a pile of papers.
Right. So the attachment is defendant's motion for preservation of Google geofence data, which was filed on April 29th, allowed by the judge on May 6th. I believe it is the second motion after the docket sheet.
I see. It's a 5-page motion.
Correct.
It says allowed.
Correct.
All right. And where is the Commonwealth's notice to Google that you say is wanting?
So the Commonwealth had Trooper Michael Proctor send over the preservation request. The first one was sent on, I believe, May 13th. And in that motion,
Do you have this as an attachment?
I don't believe it's attached to the motion. I outline it in the body of the motion, Judge.
What page?
Page 11. The section is entitled Chronology and Procedural History Relating to the Geofence Warrant.
And that's
That is-
an attachment 28? The attachments that I have are not numbered. There's a footnote here, footnote 35, that references Exhibit 28. Is that the
Correct.
preservation
That's
order?
correct, Judge.
Do you have a
yes.
copy of it that I can take a look at? Because
That is something that we
Oh,
delivered.
hold on 1 second. I think I may have just inadvertently turned to that page. This is May 13 of 2022
Correct.
from Trooper Michael Proctor.
Correct.
Yeah, that does not look like it addresses the geofence data that was ordered.
Right. And what it did, Your Honor, was narrow the requested geofence data for only apps that were downloaded from the Google Play Store, which would essentially eliminate 70 or 80% of the cell phones in existence, since iPhones and Apple carry such a large part of the market. So we contacted ADA Lally to inform him of this, and then another modified preservation request went out, which appeared to be satisfactory. But the problem is Google only sent an automated response saying that it had received the original flawed first preservation request. And then Google never sent anything to say, we will actually preserve the data. We have never received even an automated request from Google that they would preserve the iPhone data in the corrected preservation requests. And then, we have other issues.
Do I have the corrected version in the package of material you submitted?
Yes, I believe that is Exhibit 41. I'm sorry, Exhibit 31. It's footnote 41.
Amendment to preservation by Michael. This is May 19?
Correct.
All right. So you're just trying to get confirmation that Google has received and will comply with the amended notice?
Correct.
Okay. Any problem with that, Mr. Lally?
I'm sorry, problem with what, Your Honor?
The notice has already gone to Google.
Correct.
Seeking to have them preserve the geofence data. Is there any way to get confirmation from Google that they've received it and are doing that?
You can certainly get, I would imagine, yes, we could
I would
certainly
think
get
so.
confirmation if it exists, yes.
Okay. All right.
There are two ways, Judge. The first way would be an automated response from Google saying, we received your request, we'll get to it. And then the second would be where the rubber meets the road, which is we will preserve the data. We don't have either with regard to the amended request.
I understand. So Mr. Lally has to make some inquiries or have his trooper make some inquiries about what the status is with Google of that preservation request. And hopefully you'll have that answer by whenever we have a hearing on all the motions.
Yes. And
I don't think it requires a further order from the court. You're just trying to get some information as to whether Google in fact got that preservation order.
right. Although if the court does not order Mr. Lally to do it now, then I didn't understand the court. Is the court ordering Mr. Lally to do it or not?
No, Mr. Lally's agreed to do it.
Okay.
And I don't think I need a court order. I'm asking him to do it. He's agreed to do it.
Okay. That's
It's going to take some time to get a response from Google, perhaps. So hopefully we'll have an answer by the next hearing.
I'm hoping. And Your Honor, just one issue regarding the previously allowed by agreement motion for preservation of samples for independent testing. The only thing I forgot to mention to the court is that the medical examiner's office had flagged that it would be destroying samples 9 months after receipt. And that date is coming up and likely will occur before our next court date. So time is of the essence. That's why we needed the hearing to go forward today. So my hope is that ADA Lally or somebody from his office today or tomorrow will contact the ME's office to say, do not destroy samples of anything taken from the...
I've ordered it. You can take a copy of my motion and you can send it to the crime lab. You can send it to the CME, and Mr. Lally can do the same thing.
Thank you, Judge.
Okay?
Here, I'll go one step further. I will send an email to the lab and I'll CC Mr. Yannetti on the email.
Great. Next dates, you folks had an agreement to a date?
We do, subject to the court's approval. We had discussed 2 p.m. on October 4, Judge. All counsel are available.
Judge Canoni will be in the session that day, and that date, for some reason, is not available on her calendar. You can't do the 4th, 6th, 11th, or 12th. Most other days it would work.
What about October 3rd? Would that be possible at 2 p.m.?
Yes.
That's fine, Your Honor. Just as long as I can understand, as far as the Rule 17 is concerned, I just want to, are we at the 17A2 stage? We're going to be arguing.
We haven't had any hearing on the 17
okay.
motions. So
Understood.
this is a first hearing on a 17 motion. Okay?
I just want to make sure my obligations about notifying parties to be here or not.
Right.
Okay. Thank you.
Okay?
October 3 at 2 p.m. That'll be for motion hearing date.
Thank you very much, Your Honor.
Thank you.
All right. And I'll get a proposed form of an order from you, presumably by tomorrow.
Hopefully by the end of the day, if not
Okay?
tomorrow.
Very good.
Thank you, Your Honor.
Let's recall number 2, Commonwealth vs. Robert 20 CL 143.